All right. Here's what we're going to do for the next 2 weeks. We're going to talk about employment law today, Thursday, and next Tuesday. So we're going to spend 3 class periods on employment law. But next Thursday, we won't have class. Not this Thursday, but next Thursday. So you're going to have one assignment for this whole 2-week period, and it won't be due until the end of week 9. So you don't have anything due this week. So at the end of next week, which is October 17th, I think is how our week's end, you'll have one assignment, which is going to be just like the ones you've been doing. It'll have multiple choice, true, false on the lecture and the cases and the things we talk about. And then you'll have one discussion question, and that's it for the next 2 weeks. So it's not too much of a heavy load for you over the next couple of weeks. Y'all probably having midterms. People having midterms right now? Okay. Well, good. Well, maybe that'll help y'all out some. But I know I'm not going to be here next Thursday, so I just thought that this would be a good place to fit in employment law. Of the things we talk about in this class, I think employment law is one of the ones that'll have the most direct application to you and your jobs. You will run into employment law issues, whether you're the business owner, whether you're the lowest level employee, whether you're a mid-level manager. All these things come into play. So this is an area where you'll hopefully take with you some practical things that you can use. The basis of employment law is the employment at will doctrine. And so employment law is regulated on the state level and the federal level. So each state has their own laws that govern employment, and then we have a federal framework of laws that would cover everybody as well. So depending on what state you're in, or the state you're doing business in, you're going to be subjected to the laws of those states, plus the overarching federal laws as well. But the basis of employment law is the employment at will doctrine, and that is this, that in general, employers are free to hire and fire employees however they want to. That if I have an assistant in my office that I just get tired of, then I can tell her tomorrow morning, you're fired because I'm tired of you. You're fired because you're an Auburn fan. You're fired because I don't like the perfume that you wear. You're fired just because I want to be mean. Employment at will means that you are working at the pleasure of the employer. That's where we start with employment law. And then from there, we have certain state laws and certain federal laws that will carve out protections for employees for reasons that they can't be fired. I can't say I fire you because you are from Russia. I can't fire you because you're a Baptist. We're going to cover all those. That's the whole employment discrimination area. But the general rule is you can be fired for any reason, so long as there's not a law out there that prevents it. I'm not going to expect you to have the employment laws memorized. The goal, again, is like with everything we do in here, just to give you a general idea of the different laws that are going to be applicable to you. And then I want us to be able to analyze certain employment law scenarios and be able to think through them as how the laws may apply to them. But just generally, no. The general employment at will idea is that you can be fired for any reason so long as there's not a law that prevents it. And we're going to talk about a lot of the exceptions, I guess I would say, to the rule. The first category of employment-related laws that we want to look at are the ones that govern wages and hours and leave. So each state has, there's a federal minimum wage law that sets the minimum hourly rate that an employee can be paid. And then each state could go in and set their own minimum wage rates that are, as long as they're higher than the federal minimum wage. The state can't go lower than what the federal law mandates, but a state could raise the minimum wage above what the federal law says it is. So depending on what state you're operating in, the minimum that you must pay an hourly employee would depend on the laws of that state in conjunction with the federal law. We have laws that cover, that prevent child labor. I mean, you're all probably familiar with that. Children under 14 can only work in very limited occupations. Children under 16 can't work full-time, except for if they're working for a parent under certain circumstances. Again, I'm not going to hold you to the details and ins and outs of this. Just know in general that there are federal laws that govern the ages that it's acceptable for a child to work full-time. The overtime laws, as part of the Fair Labor Standards Act, are confusing sometimes to folks. And here's how they work. You are, if you're an employee, you're either exempt from overtime laws or you're not exempt from overtime laws. And the employer is not the one who has the final say on whether you're exempt or not. The law talks about who's exempt and who isn't. So sometimes employers will classify an employee as exempt from overtime when they're not. And the reason they want to do that is because they don't want to pay overtime. So if you're in any job as an employee and you're worried about whether you're being treated fairly when it comes to overtime, then the question would be, what are my job duties? And under the law, is that more of an exempt job, or does that fall under the category of non-exempt jobs? So it's not like there's this appendix where you can just look up a job and it says whether it's exempt or not. It's going to depend on a bunch of different factors, such as most people who are exempt from overtime are management type employees. Their primary duty has to be management. They are paid a salary, obviously, instead of the hourly rate. They typically, their jobs will involve use of discretion or judgment, or some sort of independent judgment on important matters. So more of your management type folks. Those are the jobs that more often than not fall into the category of exempt, meaning you're paid a flat salary no matter how many hours you work. Exempt is not hourly. Non-exempt employees who are hourly are paid on an hourly basis, and they are entitled to overtime pay if they work more than 40 hours a week. Some employers in some states will measure it on a 2-week average, so that if you work more than an average of 40 hours in a 2-week period, you'll get overtime. Some employers can, sometimes the rules are a little bit different, but the general idea that I want you to know is that any hour that you work over 40 hours in a week, that entitles you to time and a half. So your hourly rate plus 1/2 of your hourly rate. So if I make $10 an hour and I work 50 hours, I'll get paid 40 hours at $10 an hour, and I'll get paid my overtime 10 hours at $15 an hour, time and a half. Anybody have a job that they frequently get overtime in? Nobody? Anybody as a salaried employee? Okay. You are, Mick? Did you have the discussion with your employer about whether or not you were exempt from overtime, or it applied to you? I don't think overtime applied to me. Okay. So you're not paid on an hourly basis. I am paid on the hourly. Okay, so you probably are not exempt from overtime. You just don't ever hit it then, huh? But yeah, if your wages are calculated based on an hourly basis, then you should be eligible for overtime. Overtime, I mean, nobody wants to work too much, but time and a half is pretty good. So some of the times when you have to do it, you are rewarded for it. But that's kind of how the overtime provisions work. And so the question for you, if you're in a management role or you're a business owner, is that you need to make sure that your employees are classified properly. Because again, remember, just because you say somebody is a salary worker who's exempt from overtime, you need to make sure that that's what the law would say when the law examines the job duties and the title and the actual function of that employee. Because what you don't want to have happen is getting sued later on or having a government agency come in and audit you and determine that you owe a whole bunch of back overtime to these employees that you've overworked and that you've underpaid according to the overtime laws. So that's kind of how that works. Again, just like with wages, states could have different overtime laws so long as they don't lessen the protections that employees get at the federal level. So states, again, can add to the protections that employees enjoy, but they can't take away. So again, every state may be a little bit different in terms of how they treat overtime, how they calculate that. And they could have some different definitions of who's eligible for overtime and who is not eligible for overtime. Family and Medical Leave Act. Anybody have any experience with FMLA, either as an employee or as a employer? You have? Say that again. You got denied FMLA. Okay. What? If you don't mind sharing, tell me if you don't want to. But what was the request for? Okay. So you requested family and medical leave due to pregnancy. Who was your employer? And they denied your FMLA request? What was the reason that they gave for that? Okay, so you didn't qualify for FMLA. All right, so because normally that would be a good reason to ask for FMLA. FMLA stands for the Family and Medical Leave Act, and it's a federal law, and it allows employees who need to take time off work for family or medical reasons, like it says in the name. It allows you to have 12 weeks of leave within a 12-month period. So a calendar year's time, you can take 12 weeks. And it's unpaid in this country. The law just says that the employer has to let you take it. It doesn't say that the employer has to pay you while you're on leave. But it covers things like caring for new children, caring for an adopted or a foster child, right when they're placed with you. If you need to care for a seriously ill spouse, child, parent, things like that are covered. To care for yourself, if you have some serious health condition that prevents you from doing the essential job functions. And then it's also lumped in with family medical leave that if you have to deal with an emergency arising out of the fact that your son, daughter, spouse, or parent is a covered military member on active duty. So that could also be a reason that you could ask for family and medical leave. You got to qualify in one of those things. It can't be for something like my husband's we're celebrating our 50th wedding anniversary. We're going on a cruise. That's not FMLA. I'm going to celebrate the Braves winning the World Series. So I'm going to need a week of FMLA next week to recover from my celebration. That is not FMLA eligible. So up to 12 weeks of unpaid leave for the reasons that we just listed. The protections are that while you're on leave, the employer must keep your health insurance. Can't stop your health insurance while you're gone. And then when you're ready to come back after your leave, the employee is entitled to be restored to his or her original, but pay attention to this, or comparable position. So the law doesn't guarantee you the exact same job you had before you went out. So you do see questions like this. I'm pretty sure there's a question like this on the assignment for this. If you got a question where so-and-so went out on leave, they came back, they were placed in this job, then the analysis would be, is that a comparable job in terms of money, in terms of responsibilities, in terms of duties, in terms of title, those sort of things. So again, it's not the exact same job. You're not entitled to be returned to the exact same pay or the exact same job that you were doing before leave. Got to be something comparable. And what is comparable is going to depend on the facts of every situation. Some of you are, I'm the opposite of this. If any of you are math people, rules people, you like things to be black and white, then you don't like every time in this class when I say, it just depends on the facts of every situation, right? I mean, some of us don't like that uncertainty. That's always fine with me. I'd much rather, I like the gray area a lot better than I like the, guess what? I was 15 minutes late today. Yeah. So I don't know what your problem was, but I am, the lights are a problem. I mean, there's one person later than me today, so that makes me feel good. All right, I apologize for that interruption. So we're just talking about just this general idea that it's always going to depend. It just does. That's business law for you. It's going to depend on the facts of every situation. So what is comparable? If let's say we're in a big company and so we're working at Aflac and we have thousands of employees. So we've got people at different job classifications. It's pretty easy to compare. You know, I was a manager 1 or supervisor 1. When I return, I want to be in some job that's also within my same job title, somewhere within that same category or same level of job that I held before. It's a lot easier to do the comparison in a large company with a bunch of employees. It's not so easy in smaller companies because, and I think that FMLA is written this way really to protect, well, it's written this way to protect employees, obviously, to protect their ability to have a job when they come back from leave. That is important. But the wiggle room, the word comparable position really protects, I think, smaller employers who might not have, let's say I have 50 employees. And if Amanda goes out on leave, family and medical leave for her pregnancy, she might be the only person at my business who does the job she does. So I can't just leave it open for 12 weeks. And I would be okay under the law to move somebody else in her position or hire somebody to replace her, so long as when she comes back from having her baby, that she's in a comparable position. So what's comparable in my little 50-person business is going to look a lot different than what's comparable in my 5,000-person business. That makes sense to you. So I think that's why it's written that way. It's not written as a way to punish employees, but to recognize that employers are going to have unique needs, maybe the smaller their businesses and the fewer employees that they have. Employers that violate the FMLA can be sued for that, and the penalties would be, back pay, damages, cost fees. I mean, you don't want to be on the wrong end of that as an employer if you've done somebody wrong on their FMLA. This law covers employers with 50 or more employees. And so in my example about the law being written to protect smaller employees, the smallest that this would apply to is 50 people, a 50-person job. So for example, my law firm where I have 2 employees, me and my assistant, we're not subject to FMLA because we don't have 50 employees. So I could deny my assistant medical leave to care for her husband if he was injured or if she were to need time off to have a baby. I don't have to allow her family medical leave. And again, that's for the same reason that you've got some wiggle room for smaller employers. The the law recognizes that me as a small business owner with 2 employees, I can't afford for my only employee to be gone for 12 weeks and then to bring her back at the end of 12 weeks and have her in a comparable position. I can't as a small business owner afford that. I might could, but the law is not going to require me to do that. It'd be nice if I could do that, but it's up to my discretion. So public or private employers with over 50 employees, FMLA applies to. You also have to be at your job for a year before you're eligible for FMLA. So if you get hired by Aflac tomorrow, you can't go in next week and be like, I need some family medical leave here. I'm gonna be gone 12 weeks. I have a foster child that was just placed in my home, and that's a covered reason under the FMLA. So I need my 12 weeks off. So I'll see y'all in 12 weeks, and I'll look forward to having my same or comparable position. Trey. Does that apply for promotion? No. Promotions, kind of going back to the employment at will doctrine, promotions are up to the employer. So long as they're not contrary to any of the laws, such as discrimination. So I could, if I have 2 employees at my law office, let's say they're both administrative assistants, I could promote one for whatever reason I want. I could not promote the other for whatever reason, so long as it wasn't discriminatory. If one's Baptist and one's Methodist, and I decide to promote the Methodist because she's a Methodist, and I didn't promote the other one because she was Baptist, I can't do that. That's discriminatory. Now, not to confuse y'all too much, but because we're not into employment discrimination yet, but those laws also apply based on how many employees you have. So in my example is really not correct, because in a small business with 3 employees, in some states I could not hire somebody or not promote somebody because they were Baptist, just because I'm not big enough for those laws to apply to me. I'm not going to trick y'all. None of the questions that you're going to get asked on your assignment are going to make you have to decide whether or not the person has enough employees for these laws to apply to them. Does that make sense? Okay. So that's how family and medical leave works. So if Miss Lehman had been a full-time employee for a year, then her request would have gone differently with Sherwin-Williams, because she would then have been, well, assuming they have more than 50 employees. Yeah, that's a big company. And so you would have been entitled to that time off and entitled to be restored to a comparable position when you got back. Your discussion question for these 2 weeks, so you got 2 weeks to answer it, but I've assigned to you a New York Times article on family leave, on family and medical leave. And the article looks at how other countries do it. And you'll see when you read the article, a lot of other countries have laws that require family and medical leave to be paid, that are binding on an employer. So, for example, if in Sweden, I think, one of the countries covered in the article, if you need time off for childbirth, then their laws mandate that employee will get time off, but also will get paid for the time that they're off. We don't do that in America. So your discussion aspect, the aspect of the discussion question this week is for you to read that article and then kind of think critically about how other countries do it, how we do it, and then give me your opinion on what you think is the right way to do it. No paid leave ever, some paid leave, this many weeks, that many, just, kind of what you think based on your reading of the article and your consideration of how other places do it. Obviously would be a burden on the employer to require the employer to pay the employees who are on medical leave, family medical leave, but those other countries have decided that that's a burden that the employer should bear rather than the employee from being unpaid. But it's a going to be a political consideration. It's going to be a social consideration, just depending on how that country feels. Yes, ma'am. So was that a private disability policy that they had, or was that something that Synovus offered? Okay, so that was a company benefit. So even though, so for my video listeners, she's saying that at Synovus, she had a coworker who took family medical leave, and the company had a benefit where they would pay a portion of your salary or your hourly rate while you were out, as long as you were a 30 hours a week employee. All right, so Synovus was able to make up their own rules. And again, employers can have their own rules that are that offer more benefits than the law. The law is a minimum. They can't reduce the benefits that you're guaranteed under the law, but they could increase. So in that case, Synovus said yes, even though the Family and Medical Leave Act does not require us to pay you while you're on FMLA. We have a company policy that we will pay you a portion of your salary for everybody who is at least a 30-hour-a-week employee. So that even went below 40-hour-a-week full-time employees. So that's that is a company doing something above and beyond what the law requires them to do. Anybody else have any other examples of FMLA? Questions on that? All right, let's move on to the laws that govern health and safety in the workplace and also income security. So if you're looking in your outline, we're moving to Section 3. The Occupational Safety and Health Act, OSHA. That's the same acronym for the Occupational Safety and Health Administration. And OSHA, the administration, is the government agency that carries out enforcement and investigation of the Occupational Safety and Health Act, of the actual law. So when we talked in the first week about sources of law, remember that executive agencies are a source of law. OSHA is that. OSHA makes a ton of regulations about workplace safety. And I think, if I'm not mistaken, we looked at a couple of OSHA rules and regulations, then we're talking about the height of ladders. Wasn't that was this class, wasn't it? Since that discussion, anybody notice anything in their workplace having to do with OSHA? Anything pop up that you realize is an OSHA requirement? Nobody? So you'll see a lot of the, if you work at a place where there's a break room, there are a bunch of OSHA stuff posted in your break room. Lots of posters with all this required language that a lot of the employment laws will mandate that the employer put on the wall for you. Nobody ever reads them. But if you work in a place like that, look next time and see. Anybody with military experience run into OSHA issues? Did you have that, Mr. Brian? You had your own occupational safety and health regulations, right? Yeah. Kind of their own sets of health and safety rules. So I guess that makes sense. The Army might want to do it their own way rather than let OSHA get in their business or tell them what they have to do. Yeah, right. So there's some protections for private employees that wouldn't exist in the for government employees, or at least for Army employees. So just know that OSHA covers all of these workplace safety rules and regulations. It covers injuries that are work-related. And I'm not going to quiz you on the specifics of OSHA. I just need you to know that that it is an administrative agency that carries out the Occupational Safety and Health Act, carries out that part of the law, and then that deals with workplace safety, and that it is very onerous when you get into trying to figure out if your workplace complies with OSHA regulations and laws. Because it's an agency that has responsibility of enforcing that law, they can come in and do inspections without notice. They've got some, enforcement powers that should scare or worry any employers. You never want the government storming your workplace and looking for violations of laws. Workers' compensation is an area of worker health and safety law too. These are mostly state laws. So workers' comp is mostly a creature of, depending on what state you're in, it's a creature of state law. So Georgia's workers' compensation laws are going to be different than Alabama's, going to be different than South Carolina's, will be different than Florida's. And each state has their own scheme and apparatus for how you report workplace accidents, how they determine whether or not you're eligible to be compensated for a workplace accident. They have procedures in place for how you appeal those decisions, how you determine eligibility. Again, this is not the kind of thing that we're going to require you to know the ins and outs of the specifics, just know that most states have workers' compensation laws that will pay employees who are injured while they're on the job. The trade-off for the state workers' comp laws is that if you use the workers' comp framework that the state has, then you can't sue your employer. So you can't double dip. You can't, if I'm injured working for CSU here somehow, and I'm somehow eligible for workers' compensation, I'll get paid from workers' compensation. I can't also sue CSU for the same benefits that I'm getting through workers' compensation. That's the trade-off. Employers are required to contribute to the state workers' compensation fund and the state unemployment fund, whether or not you have employees that use it or not. So as an employer, I'm paying taxes to the state of Georgia. I'm paying money that goes into the funds that pay those benefits, even if I don't have employees who are injured on the job and who are drawing from it. It's a common pool contribution system. We have laws that govern income security. That's the Social Security Act. And Social Security Act covers retirement, not just retirement, but also people who are disabled and can't work. Even before they reach the normal retirement age, you can get Social Security disability. It governs who gets survivors benefits of people who are eligible, spousal benefits, all that kind of thing. It's another area that I'm not going to ask you the specifics of how Social Security works necessarily. You just need to know that both employers and employees contribute into the Social Security system. Employees contribute to their accounts and they're able to draw against that when they retire or if they become disabled and can't work. And then employers have to contribute into that as well. It's almost like a pyramid scheme. I mean, we're all paying now for the benefits that people who are retired are getting in hopes that down the road when we retire and we draw our Social Security, that'll all be paid for by all the younger people paying Social Security and paying into the system. I don't pretend to be smart enough to know the ins and outs of how all that would work or should work. I just know that they take money from me and that hopefully one day I'll be old enough to get it back. That's the extent of my understanding of Social Security. Medicare is administered by the Social Security Administration. That is health insurance for people who are retirement age, and also for some people who are not retirement age but are disabled. That's Medicare. You'll hear about Medicaid. That's a different program that does confer some government benefits on citizens. It's not the same as Medicare. Medicaid is not an employment-based program. It's more of a need-based program, and it is supplemented obviously by the government, but it's not. Medicaid is not employment related. Medicare, we all pay into that as well. And that again is really kind of prepayment for your health insurance once you become old enough and you're eligible for the government health insurance and you're eligible for Medicare. Employers are also free to have their own pension systems or retirement systems. All those have to be in compliance with the federal law, but each employer can set up their pension or retirement plan system how they want to. So long as it doesn't conflict with the federal law, they can set it up how they want. So, what you have to, the rules for eligibility can vary by employer, by different plan, just depending how many years maybe it takes for you to vest in your benefits. All those are different depending on your employer. And a lot of you do and should, if you're able to make contributions into your, to retirement and pension benefits. And good employers are also making contributions or matching, or at least putting up some money against what you're putting up as well, so that they're contributing to your retirement benefit in the same way that you are. There are rules. The ERISA is the law that governs retirement benefits and pension plans, and they have safeguards on how the investment of those funds can be done. So let's say that Aflac, their pension plan is going to have a ton of money because employees have all contributed to it, and whoever's managing that money, they have to do so in a safe way. So the law would regulate that they couldn't use your pension to make risky investments or invest in things that are sketchy or that are likely to result in you losing that pension. So that's protection for employees as to how their retirement funds are invested. Unemployment insurance is a creature of state law. So if you are fired or you lose your job, you may not be fired, you might be laid off. If you've lost your job for a reason that is covered under that state's unemployment laws, and you might be entitled to receive unemployment pay as a result of that job loss. But it's going to depend on what that state says the qualifications are. In general, you can't have lost your job through any fault of your own. So you can't walk into your employer, tell your employer off, tell your boss off, start a fight with your boss, get fired, and then head down to the unemployment office to collect your unemployment check. Generally speaking, it can't be your fault that you were fired. But if you're laid off because there's a reduction in force because of economic reasons, or you, for anything that's not your fault, then you're entitled to go down and get unemployment. And then those benefits last. The amount you're entitled to and how long they last depends on what that state law says. During COVID, if you remember, if anybody had any experience with unemployment, the federal government mandated that unemployment covered longer periods than each state had to protect the people who were out of a job during COVID. There were a lot of unusual things that happened during that time period, but the extension of unemployment was certainly one of them. COBRA, that is a law that you don't need to know what the acronym stands for, but that is the law that deals with health insurance benefits. And the important thing to know about COBRA is that if you lose your job, whether it's your fault or not, this is not like unemployment, you lose your job for whatever reason, you're entitled to continue your health insurance. Now, you got to pay for it, but it protects you from losing your health insurance just because you lost your job. So if tomorrow I get fired by CSU, I don't lose my health insurance as of tomorrow, so long as I'm willing to pay the premiums for it. And that protects me and my family in the event we need the health insurance while I'm looking for another job or until I get my own health insurance. Usually, I would tell you, COBRA is usually not a good deal. It's usually more expensive. Well, it's going to depend on your employer. A lot of times, it's more expensive than what you could just go and get your own health insurance policy for. But to the extent you've got, like, say you really like your health insurance and you've got doctors you need to go to that are in that network, and you're reluctant to go and change insurance midstream, mid-year, and have to change doctors and have to do all these different things, and it might be worth it for you to pay the COBRA premiums and just keep that insurance until you have figured out what you're going to do. But just know that's always an option to employees, is that you can continue with your same health insurance so long as you want to pay for it. But the analysis you would need to do is you'd need to shop around and determine what was a better price for you, and then compare that to the coverage and see which plan makes more sense for you in terms of coverage and cost. Now, COBRA is not indefinite. So I think it's up to 18 months. Could be longer if you're disabled. But generally speaking, you could, as long as you're willing to pay for it, you could keep your insurance for another 18 months. Hopefully by that time you've gotten another job and gotten some different insurance. But that does give you a pretty good long time to do that. We skipped, in my outline I had immigration law, but in your outline I think I took that out. So you shouldn't have anything in your outline on immigration law. We're not testing that. We're going to go ahead and start on employment discrimination today, because that typically takes a long time. So I'll use this class and the rest of this class and Thursday's class to talk about employment discrimination. So now we're at the part of employment law where we're talking about all the reasons that you cannot fire an employee for. Started the day talking about the employment at will doctrine. You can fire an employee for any reason so long as it's not against the law. Well, the Civil Rights Act of 1964 is the law that establishes employment discrimination. And it creates all the categories of people that are covered and protected from being fired for a discriminatory reason. It's a federal law, and it applies to employers with 15 or more employees. So Family and Medical Leave Act, when we were talking a little while ago, that was for employees with 50 or more. The Title VII of the Civil Rights Act of 1964 applies to any employees with 15 employees or more. Now, again, states could have their own individual laws that offer more protection to employees. So Georgia could, if they wanted to, write their own anti-discrimination statute that applies to people with employers with 10 or more employees or 5 or more employees. It would just depend on the state. Title VII also creates, well, let's talk about the protected categories for a second. In general, the categories that Title VII says you cannot use as a basis to have any adverse employment action. Denial of a promotion, obviously being fired is an adverse employment action. Not being hired is an adverse employment action. You can't make any of those decisions on the basis of race, color, national origin, religion, gender. That's listed in your outline. First sentence of your outline under Section 5. All those categories are listed. 2 summers ago, the Supreme Court heard an employment discrimination case where an employee sued for being fired because of his sexual orientation. It's a Georgia case, and it's one of the cases that you're assigned to read for the next 2 weeks. It's Bostock versus Clayton County. And Mr. Bostock sued Clayton County because he believed that they fired him because of his sexual orientation. He sued them. And at the intermediate appellate court levels, he lost because courts have held up until now that Title VII does not protect, that sexual orientation is not a protected class under Title VII the way that race, color, religion, national origin are. So all of the cases up to 2 years ago had interpreted this statute when we say that you cannot be discriminated on the basis of sex, gender. Courts held that that did not include sexual orientation. That was, so in other words, that was a permissible reason to fire somebody. But Mr. Bostock's case made it to the Supreme Court. The Supreme Court agreed to hear it. And in that case, they overturned all these past years of precedent. And they said, no, we read Title VII of the Civil Rights Act of 1964 to say that it does prevent basing a hiring decision or an adverse employment decision on the basis of sexual orientation. So once the Supreme Court ruled that from 2 summers ago forward, now this law does cover that. So that's an example of how the law changes over time. But when I don't think I've had a version of the textbook. Of course, we're not using a textbook, but the one that I take all this from is still not updated to include sexual orientation as a protected class. It drives me crazy that it's not current in that way. The Civil Rights Act of 1964 also creates a government agency that is tasked with enforcing and overseeing employment discrimination in the workplace. It's called the EEOC. You've all probably heard of that acronym, the Equal Employment Opportunity Commission. And their job is to investigate employment discrimination. Their job is to adjudicate and decide claims of employment discrimination before they make it to the court system. So, for example, Title VII requires that before you sue your employer for violation of that law, you've got to first file a claim with the EEOC. This is somewhat unique in our legal system. The law gives you the right, or the law protects employees from being discriminated against, but it also is very specific about how you go about enforcing that right. So before you can sue, you have to file a claim with the EEOC. So when I first graduated law school and I went to work for a firm in Atlanta, I went to work for one of the bigger firms up there, and I mean, it's kind of a sweatshop. And I was in the labor and employment section. So our clients were mostly like Georgia Pacific, back when it was a public company, Georgia Power. We had a bunch of mostly large institutional clients. And one of the things that one of my jobs was that anytime one of our clients got a claim filed against them with the EEOC, then we had to respond to that. We had to defend that claim before the EEOC. I think that the EEOC can be a giant waste of time, because in this way, it probably saves the courts from being flooded with employment discrimination lawsuits, but it's a waste of time in the sense that you can still sue your employer no matter what happens to your claim at the EEOC level. So if the EEOC, if I believe that Columbus State fires me because I'm a Methodist tomorrow, and I want to sue them for employment discrimination, I've got to first file my claim with the EEOC. And it's very much like the litigation process. I'd file a written statement of my claim, then Columbus State would get a chance to file their written response and provide any documents that they want to provide. And then the EEOC will make a determination. and they make they either find that your claim is unsubstantiated, or they give you a right to sue letter. So it's kind of like getting that, and you can sue no matter what. It's like getting your ticket to Hollywood on American Idol. You got to go to the EEOC first, go through their process, then you get your right to sue letter. That's your ticket to go to court. Then your claim is ripe to be filed in a federal court lawsuit or state court lawsuit for employment discrimination. So the important thing to know about EEOC is just that that's where you've got to go first if you want to enforce your rights under Title VII of the Civil Rights Act of 1964. The EEOC has to be your first stop. Sometimes the EEOC will read a claim and decide that what happened is either bad enough or involves an important area of the law that's something they want to take on themselves, and they'll sue your employer for you. That doesn't happen very often. But there's some things that they're like, oh yeah, we got you on this. We're going to sue your employer for you on this one. A lot of times that will be maybe if there's a bunch of employees who are suing for the same reason, the same employment decision has affected a big group, and it would make sense for the EEOC to bring the lawsuit rather than for each of these employees to do that on their own. The EEOC might decide to sue for them. But that's kind of how that works. A class action lawsuit is when there is a group of plaintiffs who sue the same defendant for similar claims. In the employment law context, that would be, let's say that Aflac has a testing policy for its managers, and over a period of 10 years, it turns out that members of the Latino community score disproportionately lower on this test than everybody else. And when they look at when you take that as a whole, all of these employees who are going to claim that the test was unfairly discriminatory against them want to sue Aflac. That would be much more appropriately done as a class action lawsuit. Same claim, it's going to be the same evidence. It would behoove the plaintiffs to all band together, and it would be really better for the company as well to not have to defend it 500 different ways. So that's a situation where a class action might be appropriate. I don't think I want to get into intentional versus unintentional discrimination today because that's going to take me a little while. So that'll be a good place for us to stop. And on Thursday, what we'll do is I'll finish lecturing on employment discrimination, and then I may have some stuff that we'll discuss, but it'll be stuff I'll provide. Next Tuesday is when you're going to need to come to class having read the cases, the 2 cases that you're assigned, and the family leave article. So next Tuesday will be our discussion for all employment law related topics. All right, I'll see you all Thursday. If you came in late, come see me so I can make sure I got you on the roll, but also so I can tell you what I said at the beginning of